There's a request that we try and finish by 4:15, so I will try my best. Amendment of pleadings. Rule 52 deals with amendment of pleadings. Now, amendment of pleadings is something that's changed significantly. The approach to amendment of pleadings has changed significantly with the introduction of the new rules, and it's been the subject of much debate in our courts of late, and it has caused a number of parties a lot of heartache. And you can have a look at Rule 52. What essentially Rule 52 requires is where a party wishes to amend a pleading, any pleading can be amended, but of course whether any pleading whatsoever can be amended is questionable, but we'll deal with that in a moment. So Rule 52, if you want to apply for an amendment of your pleadings, you follow the procedure set out in Rule 52, which says you need to deliver a notice to all the parties to the suit, setting out exactly what it is that you want to amend. Say, I wish to amend paragraph 1 of the particulars of claim, or by the following, deleting the whole paragraph and substituting it with the following, or deleting that sentence and putting in this, or whatever. You can obviously apply to court. I mean, you can seek an amendment of any of the pleadings, even a plea. Of course, if you want to remove an admission in a plea, you can't do that by way of amendment, simply that you'll need leave from the court. In any circumstance, you want to withdraw an admission, leave from the court is required. The notice will then set out exactly what it is that you want to amend. It could be merely cosmetic issues, or it can be rather substantive, such as instituting a further claim, new cause of action, etc., etc. So it depends on the circumstances. Then the objection is delivered to all parties, and they have 10 days. The notice is delivered to all parties, and they have 10 days to object. So if a party wishes to object, they must do so within 10 days. If there is no objection to the proposed amendment within the 10-day period, then the party seeking the amendment can apply to court within 5 days thereafter can deliver the amended pleading within 5 days thereafter. If there is an objection, then the party seeking the amendment and wants to pursue the amendment despite the objection thereto will then have to apply to court, and that is a substantive interlocutory application, which means that you need to comply with Rule 32(9) and 10 before you can proceed with before you can file and deliver your application for an amendment. Now the next question is, what must an objection contain? Please again be mindful that the notice would read something like, be pleased to take notice that the plaintiff intends to amend its particulars of claim by virtue of the following. Then 1, by deleting paragraph 1 and replacing it with the following, or by deleting the words in the period between in the first line of the 6th paragraph and replacing it with the following, or introducing the following as paragraphs between paragraphs so and so, renumbering that. So everything you want to do, you need to set out in the notice so that the person to whom notice is given knows exactly what it is that this person wants to do, and then can decide in an informed fashion whether he or she wants to object. Once an objection is filed, it must state clearly and concisely all the grounds for the exception. For the objection. Wow, I think my brain is asleep. It should set out clearly the grounds of objection. Now, after filing the amended pleadings, the opposing party has 15 days to plead thereto or amend any pleading already filed. That is in terms of the previous rule. So what you have essentially now is that the judge would manage. Once the amendment is granted, the party has a certain period of time that will be dealt with in the case plan. The party then has a certain period of time and to file an amended pleading to cater for the amendment. And that amendment that follows the amendment. In other words, you have now changed your particulars of claim, and the plaintiff now obviously needs to amend his plea to deal with the amendments in the particulars of claim. This amendment will be part of the wasted costs occasioned by that amendment, because this wouldn't have been necessary if this wasn't necessary. Or at least the initial one in the way it was wouldn't have been necessary, so it could have been dealt with in the beginning. So there are wasted costs, and the party seeking an amendment would have to pay the wasted costs occasioned by the amendment. So please be mindful, it's not 15 days necessarily, it depends on what's set out. 15 days is the norm. That's what the court usually leans toward in a sort of a regular, everyday matter, except where it's a matter of complexity or where the circumstances dictate that a longer period should be granted. But the court will regulate that by way of order in a case plan when certain amendments need to be, further amendments dealing with the amended pleading needs to be filed. Now, a party filing an objection cannot simply object because they don't like the amendment or because the amendment introduces facts which will be damaging to the defendant or to the other party, or because there's now another cause of action or a new cause of action, unless, of course, it's a cause of action that may have prescribed and now being sought. Because remember, once an amendment is granted, it's retrospective. So if the particulars of claim, maybe I should just illustrate this here. An amendment has retrospective operation. So let's say the particulars of claim and the summons, my word, was filed on 14 March 2016. The claim became prescribed if that wasn't filed. Claim would have become prescribed on 31 May. This is now a claim for, let's say this is claim X. Claim Y. Claim Y would have has become prescribed there. Now, the plaintiff seeks an amendment on 21 June 2016 to also introduce claim Y. So he has two claims against the defendant. There's nothing prohibiting a party from introducing a further or a new cause of action by way of amendment. And that per se is not a ground for objection. But let's say claim Y has in fact become prescribed after issuing of summons of this one, or even before, doesn't matter. Now, if you introduce claim Y here by way of an amendment, its operation is retrospective in that it would be as if it was here from the beginning. So you see what would happen. It's as if claim Y was already included here, where in fact it has become prescribed. So that would be a reason to object to the introduction of a new cause of action here, but not simply because it's a new cause of action. That in itself is not sufficient to object. So objections would be generally late stage of the proceedings, or it amounts to the withdrawal of an admission, or it is a change of stance which is not explained, it's not bona fide, it renders the particulars of claim excipiable. Any amendment that would render the pleading which is sought to be amended excipiable should not be allowed. Or it seeks to introduce a prescribed claim retrospectively. These are examples of grounds of objection to an amendment. As I said, costs. The party seeking the amendment should pay the wasted cost occasioned by the amendment. And even if it then proceeds on an opposed basis, to court, and the court then finds in favor of the applicant and allows the amendment, even then that party should pay the wasted costs occasioned by the amendment because it remains an indulgence. The only exception is similar to condonation, where the objection and the opposing of the application for amendment was obstructive and vexatious and mala fide. In such an instance, that party should not, in fact, a cost order should be granted against a party who obstructively or vexatiously opposes an application for an amendment that should have actually not been opposed. So where the grounds for objection show that there's actually no reason to object. Okay. Withdrawing an admission, you can do so with leave from court. What about the amendment of an affidavit? So you say you file a supplementary affidavit. Is that then how you amend? So you can't use the procedure in Rule 52 to amend an affidavit, because strictly speaking, an affidavit is evidence under oath. You cannot amend it. But people make mistakes, so most certainly if you have filed a founding affidavit and here comes the answering affidavit and you realize that from one of the answers you go back to your founding and say, oh my word, I got this date entirely wrong, it's not correct, it's not 2016, it's 2014. Then you can rectify that in the replying affidavit, or you can apply to court for leave to file a further affidavit to deal with this incorrect allegation and to say, well, I made a mistake, this is why I made the mistake, this is how it came about. It was innocent, I didn't mean to make myself guilty of perjury, and I certainly didn't mean to lie. But and that would obviously go to credibility, but you don't amend an affidavit, even though affidavits are considered pleadings in motion proceedings. What about a notice of motion? Can you amend a notice of motion? The answer is yes, you can. And to amend a notice of motion, you use exactly the same procedures set out in Rule 52. File a notice of amendment. Amendment of a witness statement. What about that? Can you amend a witness statement? No, you can't. A witness statement is changed as it's read into the record, as we've spoken about earlier, which means that a party who reads that into the record should make the necessary changes, and once it's read into the record, it becomes evidence under oath. So you don't amend a witness statement. All right. So then on that high note, it's important to have regard to case law relating to amendments. And a general point of departure in order to consider what the courts consider and what the important considerations are in respect of whether or not amendments will be granted was set out in the matter of I.A. Bell. Now, please bear in mind that it is expected of parties right at the outset to draft their pleadings with precision and with particularity. I can refer you to the case of Coastal Fish Traders Limited. Coastal Fish Traders Limited versus Wilson and another, 2006, Volume 2, Namibian Law Reports, page 573, High Court, and the reference that I'm referring to is at page 577. And it says, pleadings must be prepared with as much precision as possible, and the emphasis is in preparing right at the outset. Practitioners are required to employ precision in the preparation of pleadings. So practitioners and litigants are discouraged from seeking amendments because of shoddy work. Practitioners should be diligent right at the outset in preparing pleadings. Situations change, instructions change, life happens. So yes, of course, that's why amendments are possible, but it's not there for the taking. So there's a Supreme Court authority, a 2002 authority. It's Ciba Gagey Pty Limited, Ciba CIBA, and then dash GEIGY, Pty Limited versus Lishoff Farms. Lishoff is LUSHOF. Farms Pty Limited, and the citation is 2002, Volume 2, SA Law Reports, 447, Supreme Court of Appeal, at page 462 to 464, and that is where amendments are brought at an advanced stage of proceedings. There are important additional considerations that apply. 1, the party seeking the amendment must prove that it did not delay the application after he or she became aware of the evidentiary material upon which it proposes to rely for the amendment. 2, the party seeking the amendment must explain the reason for the amendment. And 3, the party seeking the amendment must show prima facie that a triable issue exists in respect of the proposed amendment. Now, all of this was dealt with in the matter of IA Bell equipment. It's not the IA Bell matter I referred you to earlier today. It's another matter by IA Bell Equipment Company Namibia Pty Limited versus Roadstone Quarries CC, full bench of the High Court. The case number is Roadstone Quarries CC. And it is 2 case numbers, so I can only guess that it's been consolidated. The one is case number I-601 of 2013, and the other one is I-4084 of 2010. And in paragraph 26, the court then says that the common law regime, because you know that you can seek amendments up to before judgment. It was delivered on 15 October 2014. So, you must remember that a party is entitled to seek an amendment right up to before judgment is granted. So, of course, it's an avenue open to parties all the way up to when judgment is granted. Even on appeal, you would be entitled to seek an amendment. But of course, considerations apply, and the court says in the IA Bell matter, the common law regime governing amendment of pleadings was very lax in Namibia before the introduction of judicial case management, a civil litigation process in which the judge confirms the pace of litigation. The parties are required to cooperate with the court through early and thorough preparation, identify the main issues in dispute, both as to law and fact. The interest of the administration of justice requires that costs are limited as far as possible and that hearings take place on dates assigned by the court for a matter, and parties are required to make early and automatic discovery without the need for being called upon to do so. So the court says, well, amendments in common law, and as you would read about it in works such as Herbstein van Vinsen, has a very lax approach. But now we need to look at that approach from a judicial case management point of view. And we need to ask ourselves, is what we're doing here, is that in keeping with the judicial case management system? So as from paragraph 50 of that judgment, the court then proceeds to deal with the approach on amendments And if you read this, then you should have the approach to amendments well versed. The unchanged position under the rules of court is that an amendment may be granted at any stage of a proceeding, and the court has a discretion in the matter to be exercised judicially. The common law position that a party may amend at any stage of proceedings as long as prejudice does not operate to the prejudice of the opponent remains, save that, like every other procedural right, it is also subject to the objectives of the new judicial case management regime. And then the court says, again with emphasis on the judicial case management system, and it deals in paragraph 50 and 51 of that judgment with the spirit of the judicial case management system. And I think you should read that. It also has a reference to the Ausen Care Farms with the Namibia Development Corporation Supreme Court matter. And so read through that and see what this, it's a good, although this matter deals with amendments, it's a good explanation of judicial case management. Then the court says in paragraph 55, regardless of the stage of the proceedings where it is brought, the following general principles must guide the amendment of pleadings. Although a court has a discretion to allow or refuse an amendment, the discretion must be exercised judicially. An amendment may be brought at any stage of the proceedings. The overriding consideration is that the parties in an adversarial system of justice decide what their case is, and that includes changing a pleading previously filed to correct what it feels is a mistake made in its pleadings. Although concessions made in a pretrial order are binding on a party, being an admission, they can be withdrawn on the same basis as an admission made in a pleading. Facts admitted in case management orders are not that easily resolved than those in pleadings. That is so because a legal practitioner is presumed, because of the new system which requires them to consult early and properly, to have done so and committed a client to a particular version only after proper consultation and instruction. And then the court goes on to say typographical errors, why should that be explained under oath? If it's a typographical error, it shouldn't. But what the parties should do is give a reasonable explanation. A reasonably satisfactory explanation for a proposed amendment is strongest where it is brought late in proceedings or where it involves a change of front or withdrawal of a material admission. So you see, the longer you wait, the more significant the amendment, a change of stance late in the proceedings will require a better explanation under oath. And the court then proceeded to say explanation under oath, and in later judgments it stated that that explanation should come from the party making the application and not his or her lawyer. Although a litigant does not itself have to explain on oath the basis of an alleged mistake necessitating the amendment, meaning that it could be the lawyer who files the affidavit, its failure to do so may in an appropriate case be held against it if the explanation by the legal practitioner does not disclose good grounds for the alleged mistake or the necessity for the amendment. An amendment that is not opposed or one that is minor will invariably be granted. What is the court to do when a party says, well, true, I said that in the past, I'm sorry, but it was said in error. My case is in fact the opposite of what I earlier stated. Alternatively, I wish to completely change the basis of my case. A court cannot compel a party to stick to a version either of fact or law that it says no longer represent its stance. This is so because a litigant must be allowed in our adversarial system to ventilate what they believe to be the real issues between them on the other side. The difficulty arises if the change of front is opposed by the other side. And then the issue becomes whether it is bona fide, and the bona fides of the parties becomes the real issue in dispute or for consideration. So essentially the court says, when you are faced with an application for an amendment that is opposed, look at the stage of the proceedings, look at whether there was practitioner diligence or lack of practitioner diligence in preparation, look at whether look at the nature and extent of the amendment, whether it's a withdrawal of an admission, whether it's a change of front, significant change, etc., and then weigh that up against the prejudice that a party may suffer as a result. And then you can make certain inferences regarding the bona fides of an application for amendment based on what is your answer to these considerations, and also given what the explanation by the party seeking the amendment is, and whether a triable issue actually exists, because you may want to amend to introduce a new case based on fraud, but you have no facts, and in fact what you're relying on thus far doesn't support fraud at all, or it's inconsistent with another claim. It will result in reliance on inconsistent facts. So you can say, it's always by example, you can say the example of the prosecutor or the attorney in Cape Town who represents a party who is, or a person, an accused, who is accused of rape. And his defense, as disclosed to the prosecutor by his lawyer, is, well, I'm not guilty because I wasn't in the Cape Town vicinity on that date. But if I was, then it was consensual. So, you see, you can either rely on one of those, because either you did have intercourse with this person or you didn't. So I wasn't here, but if I was, then it was consensual. You see, inconsistent facts. So you can rely on alternatives, but they can't relate to inconsistent facts. These are all issues that the court will consider on whether or not to grant the amendment, and then whether or not it's brought at a late stage, etc., etc. And essentially, it really is an issue of considering the circumstances and the merits of the application and the case as a whole. Parties should be allowed generally to ventilate the issues properly, and they should be allowed to amend their pleadings. But that leeway is taken away in certain instances, especially where it's flagrant, in the sense that there's no diligence in preparation, or, for instance, where a party changes its stance at a late stage. In fact, one of the cases referred to one of the parties that in fact already changed or closed its case. I was recently involved in a matter where someone moved an amendment during closing argument to introduce a further cause, and I said no, certainly not, and the court didn't allow the amendment in that instance. What about a situation where an amendment is not granted? What is the person who sought the amendment to do? Are you entitled to appeal that? Question is probably no. You would have to proceed, and if you are then ultimately unsuccessful, you are entitled to appeal, and the amendment is one of the issues that the court will consider on appeal. And if the amendment should have been granted, then it may actually be referred back to the court to consider or to retrial the matter, given the gentleman concludes amendments of pleadings. Generally, yes. If that's the explanation, then the court will most certainly allow a party to change. If there are circumstances where the court will disallow that, if such a party waits until that is not prompt in bringing the application, or should have noticed this earlier, etc., etc. So the court will look at the circumstances. But if it is at the innocence of a litigant, and the lawyer went on a frolic of his own with no instructions whatsoever, and the litigant wasn't aware of this and only became aware of this shortly before the application for amendment is sought, then most certainly I cannot see how, with an appropriate cost order, a judge would not allow a party to amend his pleadings. But, as I said, it depends on the circumstances. So then that concludes what we were required to do, or what I was required to do with you. I've gone through interlocutory motions very quickly because I was afraid that we won't finish. So it might be that you have some questions on what we've done today or on the program as a whole. I'm going to use 15 minutes to do questions, the program as a whole, if there are any, and then I'll speak to you about the exam, and then I hope we'll be done by 4:15. Review is only in limited instances where the court has misdirected itself. And remember, a court of appeal will not easily interfere with a discretion that was properly exercised. So it's a very difficult matter to go and fetter with the judge's discretion as it was exercised. So no, the short answer is yes, there will be prejudice, but no, you'll have to wait until appeal. Probably you won't be able to appeal even with leave. Yes, most certainly. And if the Supreme Court then finds that the amendment should have been granted, then it will send the matter back, and wasted costs occasioned as a result of the fact that it didn't happen, would probably follow in the appeal, and you would be entitled to it. But if you are unsuccessful, nevertheless, with the amendment, the Supreme Court says, well, even with that amendment, you wouldn't have been successful. It depends on whether the evidence was then presented, how the evidence was presented, etc., etc. A court won't simply just disallow a party to amend. Please be mindful of that the court wants the parties to properly ventilate the issues, but the court also needs to protect interests this way or that, and therefore stringent rules are set for pleadings. But if you are in any event, would have been unsuccessful, even if the amendment was granted, then it matters not whether you had costs afterwards. It seems like you are all spent and want to rest before you start with a new section tomorrow. All right, perhaps I should just mention then, regarding the examination, I can tell you this. The areas that I've touched on in my lectures are all very important, but of particular importance, you need to know and understand the judicial case management system as a whole and the principles relating thereto, because what will be expected of you is to apply those. So the questions would be mostly scenario-based, and it would require you to make a call and to do certain things or not do certain things. What would you do? It's to test a feel for your application of the principles that we have discussed here. Know about discovery, know about interlocutory motions, know about amendments of pleadings, read the cases that I have referred you to. I won't easily go outside those cases, and I won't expect you to at the moment. If you do, great. I'm not going to penalize you if you don't. So generally, know the flow of pleadings. And know Part 6 of the rules. I've tried to explain these things to you by way of examples, practical examples, in order to explain how it works in practice. So when you prepare for the examination, try and visualize for yourself how this would play itself out in practice in front of you in a courtroom, because that's what would be expected. Okay. Well, with that, thank you very much for listening to me for 3 days. It's been an honor to be able to share with you my knowledge and experience, which I've gained in my 14 years of somewhat uneventful at times career. And I would be happy to assist you in any way forward, or if some of you miss me too much, you're welcome to pop in for a coffee at my chambers and we can talk about civil procedure or anything else that you would like to discuss. In your pursuit to become a judge of the High Court, I look forward to appearing before some of you in the future. And always remember, in whatever you do, especially on the bench, please strive for excellence always. Thank you very much. It's been a pleasure.